you will be pulled over. Statistically, every driver in America gets stopped at least once every 7 years, and most have absolutely no idea that the first 30 seconds of that stop determine everything. Not the ticket. Everything. What you say, what you hand over, and what you stay silent about will either end that stop in 60 seconds flat or hand a trained officer every single thing they need to search your car, seize your phone, and start building a criminal case. I am a lawyer. Here is exactly what to say. And if you want more of this, subscribe right now. We drop new videos every week on exactly how to use your rights before you need them. This is educational content only. For legal guidance specific to your situation, consult a licensed attorney in your jurisdiction. Now let's get into it. Before we talk words, we talk setup, because the 30 seconds before an officer reaches your window can either calm the entire situation down or put you on the back foot before you say a single syllable. Pull over promptly. Turn off the engine. Roll your window down 2 to 4 inches, just enough to slide documents through, not wide enough for a hand to reach in. Don't light on if it is dark. Both hands on the wheel visible still. Lock your doors. And the moment that officer starts walking toward you, say this out loud. For everyone's safety, I am also recording this interaction. That sentence does something specific. It reframes your camera not as a threat but as a safety tool, and it is legal in virtually every state. From that moment forward, everything is captured on 2 cameras. Yours and theirs. That footage is evidence. Treat it that way. Now, the 4 phrases that professional officers are not hoping you know. The first one covers the moment that trips up more drivers than any other, and it always starts with something that sounds completely harmless. The officer leans toward your window, smiles, and says, "Hey, can you pull up your insurance on your phone real quick?" And 90% of drivers do exactly that. They unlock their phone, usually with their face or their thumb, and hand it right through the window. Here is what happens next on that body cam footage. The officer opens the insurance app. While the screen is live and unlocked, they scroll. They see notification previews. They spot an open app. They notice something in the photo thumbnails. And then come the magic words. "Mind if I look at a few things on here?" The driver says nothing. That silence just documented a voluntary consent to search. No warrant. No problem. Completely legal. The driver handed over the keys to their entire digital life for the price of showing their insurance card. Here is the ruling that protects you, and it is unanimous. In Riley v. California in 2014, all 9 Supreme Court justices agreed that police cannot search the digital contents of your phone without a warrant. 9-0. Chief Justice Roberts wrote that cell phones hold the privacies of life, and that the old rules for searching physical objects simply cannot be applied to a device that contains more personal information than most people keep inside their homes. Your texts, your photos, your location history, your financial apps, your private messages, constitutionally protected. What Riley cannot do is protect you from yourself. The moment you voluntarily hand that phone over and unlock it, you have consented to exactly what Riley was designed to prevent. There is no warrant needed after that. You waived it. And here is the layer that even most lawyers do not think to tell you. Your biometric unlock, your face, your fingerprint, is legally weaker right now than your passcode. Courts are actively split. The Ninth Circuit ruled in 2024 that compelling a suspect's finger to unlock a phone may not violate the Fifth Amendment because no testimonial act was required. The D.C. Circuit reached the exact opposite conclusion in early 2025, ruling that forced biometric unlock is testimonial and protected. But what is completely settled? Your passcode. Compelling you to give up your passcode is testimonial self-incrimination under the Fifth Amendment, full stop. Before every single drive, disable Face ID and fingerprint unlock. Switch to passcode only. Your passcode is a thought inside your head. Courts cannot compel a thought. The phrase is, "I do not consent to a search of my phone." Riley versus California says you need a warrant. Calm tone. No attitude. If you have a paper insurance card, use that instead. If your only option is digital, offer to hold the phone yourself and display just the insurance screen, and say out loud that you are not consenting to any broader access. Say those words every time without fail. Because if officers had legal grounds to search that phone, they would already have a warrant. The fact that they are asking is proof they do not. The second phrase stops a trap that is already in motion before you even know it is happening. You have been pulled over for something minor, maybe a tail light, maybe a lane change. The officer takes your license and registration, walks back to his car, then instead of writing the ticket, he strolls back up and leans on your door frame. "So where are you coming from tonight? You drive through here a lot? What do you do for work?" He sounds genuinely curious. He is not. That is a trained technique, and it has one single purpose: buy time. Because right now, a drug detection dog is already en route to your location. Every friendly question that gets you talking is another 2 minutes that dog has to make it to the scene. In Illinois versus Cabal in 2005, the Supreme Court held that a dog sniff during a lawfully ongoing traffic stop does not by itself violate the Fourth Amendment. Fine. But then Rodriguez versus United States in 2015 drew the line. A stop cannot be prolonged beyond the time needed to handle the original infraction, not even by a single minute, without independent reasonable suspicion of something else. In Rodriguez, just 7 to 8 extra minutes for a dog sniff after the ticket was complete was ruled unconstitutional. The mission of a traffic stop is the ticket, the license check, the registration, and the insurance. Once that mission is done, your detention is done. Everything after that requires new justification that did not exist when you were pulled over. Here is how that body cam footage typically looks when drivers do not know this. The officer asks small talk questions. The driver answers all of them. The answers mention travel frequency, a destination, some visible nervousness. Every word goes into the officer's report. Every passing second closes the gap between the dog unit and your rear bumper. When the dog finally arrives and alerts, and in some studies false positive alert rates run as high as 40%, the entire justification for what follows was built from your conversation. You cooperated your way into a search. The phrase is, "The purpose of this stop is complete. I do not consent to extending this stop. Am I free to leave?" Respectful. Firm. Those two sentences force the officer's hand. Under Rodriguez, they must either let you go immediately or articulate, right then and there, on camera, specific independent reasonable suspicion. They cannot hold you while a dog drives across 3 counties. And if they tell you that you are not free to leave, your next words are, "I understand. I am invoking my right to remain silent." Then close your mouth and keep it closed. Being cooperative does not mean being conversational. Those are two entirely different things. The third phrase is the one that surprises people the most, because they think they are completely safe. You are not on a public road. You are in your own driveway. You just pulled in. You are climbing out of your car when an officer appears from the sidewalk and says they need to take a quick look at the vehicle. Most people step aside immediately. They think it is visible from the street. It is just a car. There is nothing to hide. They step aside and lose everything. Collins versus Virginia in 2018 changed all of that with an 8-1 ruling. The automobile exception, the doctrine that allows warrantless vehicle searches under certain conditions on public roads, does not extend to the curtilage. The curtilage is the area immediately surrounding your home, your driveway, your carport, the space right outside your front door. The case came from a motorcycle parked in a private driveway. An officer walked up, lifted a tarp without a warrant, found a stolen bike, and arrested the owner. The Supreme Court threw every single piece of evidence out. Justice Sotomayor wrote that curtilage is treated as an extension of the home itself for Fourth Amendment purposes, and that the justifications for warrantless roadside searches, ready mobility, and pervasive regulation simply do not apply to a vehicle sitting on private property. The automobile exception has to stop somewhere. Collins says it stops at your property line. The wrong move looks like this. Officer says he needs to look at the car. You say go ahead, and he walks around and spots something through the window. That is probable cause. That is a legal search. Everything that follows is clean because you consented. The right move sounds like this: my vehicle is on private property. Under Collins versus Virginia, you need a warrant to search it here. Calm. No aggression. No explaining yourself beyond those two sentences. The officer must leave, get a warrant, or demonstrate an exception that applies to your curtilage. Most of the time, they can do none of those things fast enough to matter. Know your property's layout. Curtilage is a factual question, and a vehicle parked directly beside a closed entryway has the strongest Collins protection. When in doubt, consult an attorney for your specific situation. The fourth phrase is the one that gets ignored every single time, at virtually every traffic stop, not by the driver, but by the passenger. If you are riding in someone else's car when it gets pulled over, you probably think this has nothing to do with you. You are wrong. And the mistake passengers make at traffic stops is one of the most reliable tools officers have for manufacturing the reasonable suspicion they need to turn a routine stop into something much bigger. Here is exactly how it plays out on body cam. The car is stopped. The officer looks in and says, "Can I get both of your IDs?" The passenger hands one right over, no hesitation. The officer asks where they are headed. The passenger answers. Then the officer walks back to the driver and asks the exact same question. The driver says something slightly different, maybe a different landmark, maybe a different phrasing. That is all it takes. Inconsistent statements from vehicle occupants. That two-word phrase goes into the report and becomes the documented articulable reasonable suspicion to extend a stop, request a drug dog, and justify a full search. One cooperative passenger answer created the entire legal foundation for everything that follows. The legal footing here is rock solid. Brennan versus California in 2007 was unanimous. Passengers are seized for Fourth Amendment purposes during a traffic stop just like the driver. Full constitutional standing. And United States versus Landeros, a 2019 Ninth Circuit decision, held that passengers are not required to provide ID unless individually suspected of criminal activity. Stop and identify laws vary by state. Some do require all occupants to identify during a lawful stop, others do not, so know your state. But where it is not required, handing over that ID voluntarily opens a conversation the officer had no legal right to start. The phrase for every passenger in every stopped vehicle is this: I am a passenger. I am staying silent. I do not consent to any searches of my person. Am I personally being detained? Say it once, clearly, calmly. That statement invokes your Fifth Amendment right against self-incrimination, asserts your Fourth Amendment protection, and demands a direct legal answer about whether you individually are being detained or simply happen to be in a stopped car. One important note: under Maryland v. Wilson from 1997, officers can lawfully order passengers to exit the vehicle during a stop. Comply with that order. Exiting is not consent to search. As you step out, say, "I am complying. I invoke my right to remain silent and do not consent to any searches of my person." Hands visible. Body calm. Then say nothing more. Once the stop ends for the driver, your detention as a passenger ends with it. Do not linger. Do not keep talking. You are done. Here is the only principle that ties all 4 phrases together. Officers are trained. They practice these conversations. They know exactly which questions get people talking, which silences create nervousness, and which small requests produce voluntary consents that no warrant was ever needed to justify. You were never taught any of this. Until right now. Knowing the exact phrase for each moment removes the officer's ability to build a case through your own cooperation. You are not being difficult. You are not being suspicious. You are being constitutionally educated. And rights asserted calmly, clearly, and without aggression look like exactly what they are on that body cam. Knowledge. 4 phrases. Write them down. 1. I do not consent to a search of my phone. Riley versus California says you need a warrant. 2. The purpose of this stop is complete. I do not consent to extending this stop. Am I free to leave? 3. My vehicle is on private property. Under Collins versus Virginia, you need a warrant to search it here. 4. I am a passenger. I am staying silent. I do not consent to any searches of my person. Am I personally being detained? Practice these until they come out automatically, in a calm, neutral tone, even when every instinct is telling you to explain yourself and smooth things over. In a high-pressure situation, you will default to whatever you have practiced. Make sure what you have practiced protects you. This is educational content only and not legal advice. Laws vary by state, and your specific situation may involve factors that change the analysis entirely. Always consult a qualified attorney in your jurisdiction. If knowing your rights before the moment you need them matters to you, subscribe to this channel right now. Every week we break down the exact laws, the controlling court decisions, and the precise words that keep you protected when it counts most. Share this video with everyone you know who drives. That is everyone you know. Your rights do not care whether you remembered them, but the officer on the other side of that window is counting on the fact that you did not.